All right, good morning, everyone. This is our civil pretrial conference and motions calendar for Judge Krause, and it's Friday, May 31st. Judge will be joining us momentarily. We've had a case come off just a few minutes ago. Luckily, I don't see that attorney, so they got notice that they don't have to appear, which means we are now out of motions and we are only having pretrial conferences. So we have what looks like 9 of them. So there'll be quite a few of them today. All right. I don't know if anyone has a court reporter. You might want to make the judge aware of that when your announcement comes. And other than that, she should be on momentarily.
Thank you. Now 11:13.
Good morning.
Good morning.
Good morning, Your Honor.
Good morning. Just give everybody a minute to get all the videos and stuff turned on. There we go. Okay. So I have a few matters that I think are going to take a little bit of time, and then a few matters that are probably going to be pretty straightforward. So I'm going to run through the calendar, get rid of the stuff I can that I think is relatively straightforward, and then we'll go from there. U.S. Bank National Association versus Sally Lovingood, Dina Lovingood et al. Who do I have here on behalf of U.S. Bank?
Good morning, Your Honor. Patty Whitehead.
Thank you, Ms. Whitehead. And who do I have here on behalf of the Lovingoods?
Good morning, Judge Krause. Rachel Scott from Atlanta Legal Aid on behalf of the Lovingoods. I'm also joined by my colleague Karen Brown, and we have a law student intern that's also sitting in to observe, if you don't mind.
Oh, absolutely. Happy to have young people watch good lawyering. So, okay. Okay. And obviously we're here on a pretrial conference. There are a number of, I know that there is a summary judgment motion that is outstanding. We're going to talk about all that. I know there's a disputed request for a jury trial. So we've got some time that we need to spend with that one. And so you guys are probably going to be waiting around for just a little bit until we get to you guys. But feel free, as soon as I get through everything and figure out what the lay of the land is, if there's a way, if y'all are able to multitask and, just be ready when I call you, then that's fine too.
Thank you.
Thank you. Troy Murray versus John Doe.
Jennifer DeBon for State Farm.
Okay.
Good morning, Your Honor. I'm Brittany Larkart for Plaintiff Troy Murray.
Okay. And DeBon and Ms. Larkart. Thank you. And obviously I have your CPTO. Thank you very much. And I think we just need to sort of take a few minutes to walk through that pretrial order. Any other matters besides just the CPTO that y'all think we need to take up?
Just want to let the court know that my father passed away recently and very
sorry.
unexpectedly. Thank you. And I ended up taking about 25 days of leave between March and April. And so I'm trying to dig out of a hole. And there were there was the mediation deadline that we missed, and that was in large part because of my unavailability And so we have scheduled it for mediation, but I just wanted to let the court know that that was,
Isn't it next week? I think I saw a note that it's like June
Yes.
6th, maybe.
yes, ma'am.
Okay.
And I just wanted to let the court know that was not on the plaintiff. That was my personal
Well, that's
matter.
very, first of all, I lost my mother very unexpectedly a few years ago, so I sympathize with you. I'm very sorry.
Thank you.
And I appreciate that you are back at it and have already gotten a mediation scheduled. The beauty of that mediation from my perspective is that it's in between now and the expected trial date, which would be the last week of June. So if you settle, great. If not, you guys are teed up and ready to go to trial. So we will work through those issues this morning to the extent that we need to address anything in the CPTO. Okay?
Okay.
Anything
Yes.
from your perspective, Ms. Larkart?
No, Your Honor.
Okay, thank you. McClendon versus McClendon, Mr. Bushnell.
Good morning, Your Honor.
Good morning, sir. So
Good
my,
morning. This is Monica Scott. I'm representing the defendant, Launchpad Real Estate.
yes, and forgive me for cutting you off. The only reason I started to speak, and I have another attorney here from Cash Quick Buyers, but my understanding is that all of the defendants besides James McClendon have resolved their issues, and the only remaining issue is that I I noted that Mr. McClendon was in default because I had struck his answer, but there's no resolution or default judgment, and there's an open issue of attorney's fees, I think is my recollection. Is that right, Mr. Bushnell?
That is correct, Your Honor.
Okay, well, that probably then means, Ms. Scott, that you get to jump right off the call and go back to your
Okay.
desk.
Thank you, Your Honor.
Have a good day.
You too.
Yes, so we will need just a default damages hearing.
Okay,
I
and
can
how long
make-
do you think that will take?
I have an older client, so maybe 15, 20 minutes,
Okay,
but I can't imagine taking much longer than that, Your Honor.
okay.
Of course,
Well,
we do have I don't know whether Mr. McClendon with 2 C's in his name is going to show up or be even present. So, but I know my end will only take 15, 20 minutes at the most.
well, I know we have about 5 email addresses for Mr. McClendon, so we'll make sure that he gets notice of the hearing, but we also made sure he got notice of the discovery requests he was supposed to respond to.
Hasn't responded to anything. So
Right. So what I will probably do, Mr. Bushnell, I'm assuming that it was not your intention to do that today, correct?
correct.
Okay, that's what I thought. So what I'll probably do then, Mr. Bushnell, is just find a day, reach out to your office by email, find a day that we can have a 15 to 20-minute hearing. Briefly, it will be by Zoom unless anybody objects, and send out an appropriate notice, making sure that we send one to Mr. MCC McClendon, James McClendon.
That'll be fine.
And then we can go, it will be soon. I mean, it will be in the next week or two, just to go ahead and put this issue to bed since it is on the June 24th calendar. But I mean, subject to leaves and conflicts, I understand those.
Yeah, I mean, if you could do me during the week of this trial calendar, that
Mhm.
would probably be the best, because between now and then, I've got 16 hearings in the next 2 weeks.
Holy cow, Mr. Bushnell.
and that doesn't include the trial calendars that I'm on too. So
Excellent. Well, putting it during the week of the trial calendar, which is that June 24th, shouldn't be a problem. So we'll just target it for sometime that week.
That'd
Probably provide a few dates that might work, and then we'll work around any leaves or conflicts or whatever.
that'd be great.
Okay. And you may be on your way too, sir.
Appreciate it. Thank you, Your Honor.
Thank you. Have a good day.
Bye-bye.
Patricia Farmer versus Enrique Porras.
Tom Brennan here for the defendants, Your Honor.
Okay. And do I have anyone here on behalf of the plaintiff? Okay. Mr. Brennan, if you just sit tight for a bit, we're gonna wait and see. Had you been in touch with counsel for the Ms. Farmer, or had you expected them to appear?
No, and it's actually been a problem in this case that I've been trying to get some documents from him on this case, and I probably should have filed some motion, but I abhor discovery motions, and I have not done
I
that.
do too. So if we reach that stage, or if there's an issue that needs to be addressed, my standing order just says, feel free to give my office a call, and we'll have a conference call to the extent that we need to.
Okay, well, we'll just see what happens today, Your Honor, and I'll do whatever you want to do on it.
Okay, Mr. Freehoff, are
Sure.
you checking on whether they opened the notice?
Yeah, I'm assuming that's what you would like me to do. So
Yes.
I'll do that right now.
Thank you. Okay. Just sit tight for a few minutes, Mr. Brennan, and we'll see if they appear today. Just a reminder, this is as good a time as any. Basically, every hearing I have says that it is one that if you fail to appear, I can choose to strike your pleading or grant whatever relief. So everybody should always be aware of that. Okay. Next up, Boy Wonder versus Brickcell Investment Group et al. Who do I have here on behalf of Boy Wonder?
Hey, Your Honor, Nubian Mzekwe here for Boy Wonder.
Thank you, Mr. Is it Mzekwe? Did I say that right?
Mzekwe, thank you.
Okay, thank you. And who do I have here on behalf of Brickcell? Mr. Mzekwe, I'm sorry, I'm going to mispronounce that. I'm going to try hard to say it right. But have you had any contact with counsel? I noticed they'd filed a number of motions, but had not responded to a more recently filed motion to dismiss. Did you anticipate their appearance today?
I didn't. Well, I guess I naively expected them to show up, but I haven't had any contact with them maybe in about a week and a half or so.
Okay.
So
Well, that's more recent than some. Mr. Freehoff?
Judge, I will check on that one. Just in terms of the previous matter, the Patricia Farmer matter, counsel for plaintiff did not open this notice according to eFile Georgia.
Okay.
I will now check on Mr. Yacklin or any counsel for defendant in this case and get back to you.
Okay, thank you. Excuse me. Mr. Mzekwe?
Mzekwe, yes,
Mzekwe, thank you.
All E's pronounced like A's.
Excellent. Okay. Mr. Mzekwe, I am going to ask you, as I did Mr. Brennan, if you'll just sit tight for a few minutes till we give a little bit more time to see if someone's going to appear. Although obviously I think that's unlikely given that we've confirmed that they did not open the notice that was sent to them. But if you'll sit tight with me, we'll figure out what to do with those. Okay.
Sure.
Thank you, sir. Citibank versus Eric Jordan. Anyone here on behalf of Citibank? Anyone here on behalf of Eric Jordan? Okay. Next up, Discover Bank versus Rose James. Anyone here on behalf of Discover Bank?
Good morning, Your Honor. Madge Buckle on behalf of
Buckle.
Discover Bank.
How are you doing?
I'm good, Your Honor.
Is Rose James here? I noted in the record that her I authorized her counsel to withdraw last month. Mr. Freehoff, I know you're checking a lot of things, but can you confirm notice was mailed to Ms. James at the address on file in the withdrawal notice?
Yes, I believe it was, but I will confirm that and get back to you.
Thank you. Ms. Buckle, if you'll also just sit tight until we figure that out and see if anybody is going to appear, okay?
I will, Your Honor. Thanks.
Thank you. Citibank versus Jason Aguilar. Anybody here on behalf of Citibank? Anybody here on behalf of Jason Aguilar? Okay. And then that leads us to Vianta Yancey versus Arletha Maddox. Who do I have here on behalf of the Yanceys?
Russell Hodges, Your Honor, on behalf of the plaintiff.
Hi, Mr. Hodges.
Good morning.
Good morning, sir. And then who do I have on behalf of Arletha Maddox?
Alonzo Nelson, Your Honor. Good morning.
Hi, Mr. Nelson. So couple things just to figure out where we are. One, I am aware that there is a continuance request. I am also aware that so I've ruled on I've granted a partial summary judgment in this case. I'm sure you both know that. I saw communication from Mr. Hodges. I saw, I think just yesterday, Mr. Nelson, a proposed order that came from your office, I think, as I requested, which I am intending to edit and get on file today. And then I think the real meat of the continuance, if I'm not mistaken, Mr. Hodges, is that you intend to try and seek interlocutory relief based on that summary judgment, or I didn't mean to imply that it is interlocutory or direct, but that you intend to seek appellate relief on that ruling. Is that right, sir?
Your Honor, that would certainly be my right. We have another matter. We have the plaintiff in two capacities. One is the individual capacity, tortious interference. The other is in the capacity of, and we had to put it this way because we were opposed in the probate court pending administrator. That is actually set for a pretrial, and I think will be appointed the 2nd of July. Now, we have the deposition of the defendant, whereas she says, I don't want to be the administrator. I do not desire to be the administrator. And we have submitted that to the probate.
She just doesn't want the other person to be the administrator. Is that the idea?
That's correct.
Okay.
She just doesn't want the other person. So I expect to be appointed administrator. Now, being the administrator was not served with the eviction suit, the dispossessory action way back. So they would not be bound by a counter complaint. So if they are appointed, they have the right to bring on both houses. Now, I think, excuse me, something's in my throat.
That's okay.
I would say that if we go forward on one house and then we get an administrator who goes forward on two houses, the first trial would be useless.
Okay. So I think that I want to hear from Mr. Nelson and what his thoughts are, but it does seem like if I'm going to enter a partial summary judgment order today, at the latest would be Monday. And then, Mr. Hodges would want some time to determine if he's going to, ask for a certificate and file any, interlocutory relief. And then add to that the issue of the estate. It would seem like waiting a short period of time to see procedurally where everybody ends up might make some sense before I move the trial forward. Mr. Nelson, what are your thoughts on that, sir?
I don't disagree with that, Your Honor. I'd rather try this case once with whichever party is in the case and be done with it. I think Mr. Hodges' client is trying to get 2 bites at the same apple, and we'll argue that when the case comes forward.
Okay.
If it might take 1 minute, Your Honor.
Yes, sir.
Because you've not signed the order yet, so bear with me for like a minute and a half, okay?
Well, I will, except that I've read your very lengthy, I don't know if it was a letter brief or email. I'm aware of your legal position and that you disagree with the ruling that I've advised I'm going to enter. And so I'll let you speak again, but I will tell you, I'm very familiar with what you've argued.
Okay, one thing we had not put in there, how is a person required to do a counter complaint on a forgery?
The issue isn't the forgery, Your Honor.
And we're not here to argue the merits of this issue right now.
I understand, but it should be.
This is sometimes an unintended consequence of one of my procedures, which is to say, hey, this is how I'm going to rule. Somebody give me an order. And so sometimes that invites people to then try to re-argue the issue before I enter the final order. Mr. Hodges, I understand that you disagree with my ruling, and ultimately you may, the Court of Appeals may say that I was wrong. But I've done the research and I'm comfortable with the ruling that I've entered, even if subsequently it turns out that I was not correct. And so I'm not going to change my position, and ultimately I'm going to enter an order very briefly that outlines what my position is relative to that counterclaim. And then y'all can all operate from there. Although all of this may be obviated if before you get to the Court of Appeals, something is resolved relative to the administrator, and then we can all come back and have a discussion about what issues need to go forward relative to the administrator. And so all of that is a long way of saying that it sounds like Mr. Nelson does not object to your request for a continuance. And it sounds like, given that there will be some movement in the probate court in early July, is that right, Mr. Hodges? Did I understand that correctly? That it seems like placing this for another status conference sometime in mid-July would be a good use of our time to figure out where we are, what the probate court said, if they've said anything at that point, and then what the status is of any interlocutory appellate review of the order that I'm going to enter. So that would probably be what I will do, is just have you guys come back in July. mid-July sometime to give me a status report on what's going on in the case. And then we can figure out where to put it on the trial calendar and who the parties are going to be and what the claims still are at that point, depending on probate and the appellate court. Does that work for you gentlemen, Mr. Hodges and Mr. Nelson?
It does, Your Honor. I'm leaving very quickly at my calendar in July. I have a leave of absence for about 15 days, starting on the 4th and running up to the 15th. And then I have my fiduciary seminar that I've asked for in the leave of absence that starts on the 24th. I'm on the highway. So if you're going to set one, try not to set it 24th, 25th, or 26th, or from the 5th through the 15th.
So looking at my calendar as well, your most likely dates are going to be sometime the week of July the 8th or the first few days of the week of the 22nd or the last week of July, which would be the July 29th. But I think that might be a trial week. So
what about the 22nd, Your Honor? Would that work?
The 22nd would probably work.
Let me leave it that real quick. I'm a dinosaur. I use paper.
Mr. Nelson, what about you, sir?
And I'm looking.
Oh, I'm sorry, Your Honor. I've got a 9:30 Zoom hearing. If we did it, in the afternoon or any other, actually the 22nd, I do have a 9:30 Superior Court Gwinnett County Zoom hearing.
Well, let me ask you this as I'm looking. I would likely be picking a jury on the 22nd. And so if we were to look at the 23rd at 9 a.m., that would be better. And that would still get you out. I think you said the 24th and on would be the problem for you. Is that right, Mr. Hodge?
Yes, ma'am. The 23rd is totally clear.
Okay. So why don't we do this? Why don't we plan? I'll have a notice done, but let's plan for a status conference at 9 a.m. on the 23rd of July, which is a Tuesday.
Down in my dinosaur book.
Sir?
I'm writing it down in my dinosaur book.
Hey, I'm a fan of paper as well, but excuse me, Mr. Nelson, is that going to work for you as well, sir?
Yes, Your Honor.
Okay, excellent. Well, we will send that notice out for July 22nd, 9 a.m. It will be by Zoom, and y'all can update me about what has happened in the probate court and where we are procedurally on the any appellate remedy that Mr. Hodge may seek on behalf of his client. And with that, I think you gentlemen may be excused, and I will see you on July the 22nd.
Thank you, Your Honor.
Thank you all. Have a good day.
Have a good day.
Okay. Okay, for those of you whose parties have not shown up, I'm gonna wait until about 9:30 because I think that's reasonable. And at 9:30, then I will officially declare that they didn't get their notices, they didn't appear. And because these calendars are peremptory, the court will, if it's the plaintiff, dismiss, if it's the defendant, strike the answer. So I will let you all know that in just a few minutes. In the interim, I am going to go back a little bit to the CPTO relative to, let's see, Troy Murray and versus John Doe. And the reason I'm going to do that is because I want to talk a little bit about my trial procedures, which I think will be beneficial to both the Lovingood matter and this matter, the Murray matter. So assuming that it is a jury trial, we would, I just want to let you know a little bit about what I do. Generally speaking, the procedure is the jury will be out in the gallery. I will ask some very basic general questions, just making sure they're minimally legally qualified to sit. They live in Fulton County, that sort of, they're over 18, they're not over 70 and don't want to serve, that sort of thing. And then I pretty much let the lawyers do their thing. And so I will allow you to ask the questions of the jury. Excuse me. A couple of caveats is I prefer that you only refer to the jurors by their numbers. Jurors like that. I know it feels wrong, but I tell them in advance, hey, we're going to call you by your number. Please don't think we're being rude. It's just to let you be anonymous on the transcript, right? And jurors seem to like that. They especially like it in complicated gang murder cases, but I think they also would like it more in these, and they like it in these cases as well. Excuse me. Couple of things. So what I will do is I will ask all the general questions, and then I will let the lawyers ask general questions, yes or no. What is slightly different about my approach, which is why I'm telling you, is that when you say, does anybody here have a management position? And you get 9 people that raise their card, right? That's not the appropriate time for you to then say, juror number 12, tell me about your management experience. What I would rather you do is follow the procedure, which is I'm going to ask general questions, then y'all both ask general questions. Then we put 12 jurors in the box, and you get to ask jurors 1 through 12, follow up on all that card raising and any questions that you wish to ask them. Excuse me. Where possible, if the jury can be selected in the morning, if we start early enough and can efficiently do that, you should be prepared to open at least, and possibly have a witness on standby, depending on how fast you think it will go. I do not require that you strike jurors in order. I tell you that because some people that straddle both criminal and civil, in criminal, you have to strike in order, juror 1, 2, 3, and civil, you can strike in any order you want. And the last thing I will say is about exhibits in terms of unique issue. Well, no, 2 things about my courtroom. Number 1 is we use Zoom rooms to demonstrate evidence to the jury. So, I mean, now don't get me wrong. I'm a big fan, as one of the lawyers was saying, I'm old school. So, I mean, if you want to blow something up on an actual board and put it on an actual easel, you go right ahead. If you have paper and you want to hand it to the jury and let them pass it around the jury old school, you go right ahead. But technologically, if your intention is to have PDF versions of your documents and to show them on a screen to the jury, what you're going to be doing is logging into a Zoom that we will provide every day. And then you will share your screen and demonstrate. We have a giant board that sits immediately to the, let's see, right of the jury box, right next to the witness box, so that the witness can point to things on it. We also have a touch screen that a witness can mark up a document if you want them to circle things, that sort of stuff. And here's the important but. If you want the jury to have those documents, you either have to do one of 2 things. Either you have to give me a flash drive with nothing on it but your exhibits, and I can give the jury a laptop that's completely wiped clean of anything and does not have access to the internet, and they can use that flash drive to access evidence. Or you must print out a copy of the exhibits. And especially in civil, sometimes I tell you print out a copy anyway, because Zoom rooms is unwieldy if you're trying to get a witness to identify a document before it's been admitted into evidence and therefore can be published in some manner. And so sometimes it's still helpful to have the paper copy that you can hand to the witness, and the witness can say, yes, this is what it is, and get it into evidence. Now, having said that, though, I strongly encourage the lawyers to provide me with, and to the extent that anyone hasn't already done it, I know that I've got CPTOs from the 2 sets of attorneys I'm specifically talking to right now. But the exhibit list immediately prior to trial, I really prefer it to be, if any of you've practiced in federal court, that's where I used to practice most of the time. I really prefer it to be a table with exhibit numbers, and that way I can keep track of what's been offered, what's been admitted. But what I really especially want you guys to do is please agree on what exhibits we can agree on, so that we can narrow the universe of what we actually have to argue about, or what foundational requirements and time we need to take in the trial in front of the jury with the documents that actually matter. right? So if there are 100 documents that we can all agree are coming in and we can provisionally admit, and then you can just say, hey, witness, I'm showing you this document that's already in evidence, then let's do that and limit our discussion time and the time that you have to take to say, hey, witness, look at this document. Do you recognize this document? Can you tell us what this document is? Your Honor, I move to have this document admitted. All that dance that we do, if we can dispense with that for most of our exhibits, which in civil cases, we almost always can, I really would appreciate that. It speeds up the trial immensely. On the note of speeding up the trial and the use of Zoom rooms, please take a moment to practice your sharing of exhibits. And the reason I say that is because Zoom rooms can be a little bit, if you have Zoom, just practice sharing your screen and navigating between documents, because it may not seem like it takes very much time when you're doing it on your own or, you know, in any other place. But if you have 100 documents and it takes you 10 seconds, 20 seconds, 30 seconds to get that one document up on the screen, you've just added roughly 30 minutes to our day. And if you're talking about hundreds and hundreds of documents, it starts to get real unwieldy. And I've watched jurors roll their eyes when it takes too long to get a document up, when it's like, hey, didn't they practice this? And I know you guys are all professionals, but you probably aren't professional document demonstrators, right? So either have somebody in your office that can do it for you instead of you having to do it while you're also asking questions, or practice doing it and have them all in one place where you can toggle between the exhibits without having to leave Zoom, pull up a different document and go back into Zoom, or share screen, stop share screen, etc. I've watched a lot of it, so as you can tell, it's something of a pet peeve. For both the Lovingood matter and the Murray matter, just generally any other questions that you can think of regarding sort of my general trial procedure, how I do things, that sort of thing.
Your Honor, just to clarify, as far as bringing documents into the court to share on the Zoom screen,
yes,
are we bringing in our own computers to hook up to the Zoom, or are we bringing in a thumb drive with the PDFs?
So either or. Most people, it's been my experience, bring in their own laptop. They have their documents set up the way they want them on their laptop, and then they'll just share, they'll log into the Zoom from their laptop and share screen. Now, there is a monitor on my podium in my courtroom that is one of those, I sound a million years old and not tech savvy when I say this, but it's one of those computers that's a monitor, but it's also a computer. You can plug a flash drive into it, and then you can share your documents from that screen if you choose. I am not as knowledgeable about that process, but I've seen lawyers do it. But also my courtroom is open. And if it's worth your time to invest in coming to my courtroom at any time and practicing that, making sure that you know what it is, if you let my staff know that you're coming to do that, then we will set up a Zoom for you so that you can figure out how you want to do it and that you have some familiarity with it before you're doing it in front of a jury for the first time.
Thank you.
Anything else? Okay. So with that, I have the Murray, well, hang on, let me go back through my calendar real quick and let everybody get on their way that doesn't need to still be here. Patricia Farmer versus Enrique Porres. It does not appear to me that the plaintiff's lawyer even opened the notice that the court sent to them. Also, this calendar was noticed as a peremptory calendar, and therefore the court is authorized to dismiss a case when someone fails to appear. And so Mr. Brennan, I think my intention is to dismiss this matter at the conclusion of this hearing. Mr. Freehoff, did you have some additional information?
Not on this case, sir.
Okay.
Your Honor.
That's okay. I assume you have no objection, Mr. Brennan?
I do not, ma'am.
Okay. We will enter a dismissal. I have no knowledge of the procedural posture of this case or the age on it or anything, but it will technically be a dismissal without prejudice.
That's
and
fine.
then the parties can all go from there. Okay.
Thank you very much for your time today.
Thank you, Mr. Brennan. Okay, Mr. Mzekwe. It does not have, Mr. Freehoff, have we heard from anything relative to Mr. Yaklin or anyone on behalf of Brixell or Padone or Miller?
Okay, Judge. I have sent you an email about the standing order of this court when it comes to e-filing. When I looked into this case, it appears the docket shows that counsel for which was Bush Reed Jones, they withdrew.
Yeah, I know. And then
Okay.
Mr. Yaklin
Then
appeared.
Mr. Yaklin came in. When you go into e-file Georgia, the entry that Mr. Yaklin filed on March 18th does not exist, which tells me he filed via Peach Court, which gets into our standing order on e-filing, where the clerk's office has said you have to use e-file Georgia and use a proper. The long and short of it is Mr. Yaklin did not get notice because he does not have a contact in the e-file Georgia system. When I saw his entry, I assumed, well, he's filed something into the case, so he's in there. And e-file Georgia didn't tell me that there was, lack of a service contact. And so he didn't get noticed, but he also hasn't complied with the court's standing order on e-filing by making sure he has a valid service contact in the e-file Georgia system.
Okay.
So it will be
So, Mr. Mzekewe, what are we, so it sounds as if what I need to do is renotice this matter to make sure that Mr. Yaklin's clients receive notice and see if they appear. My intention is to do that as quickly a turnaround as I can. Given that this matter was set to be on the originally, you probably know this because you're here, but originally this matter was set for a July trial, but the reason it was put on the June calendar is because I reserve the right to put it sooner if there are no dispositive motions. And so what I would probably do is renotice this matter for a date the week that this case would have been called in for trial. Very briefly, probably at 9, sometime the week of June the 24th. And make sure that Mr. Yaklin has notice, see if he appears, and then figure out what the procedural posture of your case is at that point, which would probably mean that it gets kicked. If Mr. Yaklin appears and is still pursuing or defending his clients, then that would probably mean it gets moved to the July calendar.
Okay.
Will that work for you, sir?
Yes, Your Honor.
Okay.
I do have leave. I don't know if it's been filed already, but I do have leave coming up. I think it's that the weekend of June. I think that weekend is the last weekend in June.
Okay. Well, I will tell you, I am always happy to honor leaves. It's just sometimes there's just no way we could keep track of all of them. So it's one of those things. If we send you a notice and you have a leave, just say, hey, I already had a leave. Please excuse me. And we're happy to do that.
Fair.
But I will anticipate setting it for sometime that week of June the 24th, and we will see what happens with Mr. Yaklin and go from there. Okay.
Thank you.
Thank you for your patience, sir. Have a good day. Anybody here on behalf of Citibank? Mr. Freehoff, I assume that no one opened the Citibank versus Eric Jordan or the Citibank versus Jason Aguilar.
Judge, I haven't checked those specifically, but given the history,
Yep.
But I will confirm that. And if they have not, or I assume you will.
And just confirming real quickly so I can get Ms. Buckle on her way. Ms. James did receive mailed notice at the physical address.
Yes, the notice says that she was served via her address, and if I put that in there, I did it. So
okay, Ms. Buckle.
Yes, ma'am.
That would mean that Ms. James's answer would be subject to being struck, and that Ms. James would now be in default. Do you? What I would suggest is for you to submit a motion for default judgment.
I will, Your Honor.
Okay. And if you can do that in the next week, then we'll get it on file for you. Okay.
By next Friday, I will, Your Honor.
Excellent. Thank you, Ms. Buckle.
Thanks, Your Honor. May I be excused?
Yes, ma'am. Thank you.
Thank you.
Okay. Okay, so now, because I think I can get through it a little more quickly, Ms. Devon and hang on, I've lost my notes. Ms. Larkart. Thank you.
Yes, ma'am.
Okay, so I have taken a look at the consolidated pretrial order. The estimated time for trial you guys have listed as 3 to 4 days. I assume that is inclusive of jury selection.
Yes.
Yes.
Other than State Farm and the listed qualified witnesses, anybody unique that we need to qualify, any unique reason we might need more than 36 jurors?
The only thing is that the plaintiff is a pastor at a church, so we may want to include a general question about anyone who is a member of that church or who has attended that church.
Okay.
Just in the beginning, because that would probably save time. It might be that no one responds, but if we get several people, I'm not sure how popular the church is or the attendance, but he's a very vocal community. He goes out into like underprivileged communities, so there's a chance that several people in the jury pool may be familiar with him.
Okay, Ms. Larkart, what are your thoughts?
I wouldn't object to that. We don't obviously want to have a biased jury in any way. We want them to have a fair trial. So I wouldn't object to that.
Okay, thank you. As I understand it, I mean, this is a fairly straightforward automobile accident versus a John Doe. State Farm is providing I assume this is all because of, is it an uninsured motorist claim or?
Yes.
Okay.
Yeah. The driver that caused the accident fled on foot and was never found. But there was a vehicle involved that they hit plaintiff. So it's a little.
Just out of curiosity, is there reason to believe that the actual owner or someone authorized to be in possession of the vehicle was the person who fled on foot?
It doesn't appear so. The car had not been registered for 2 years.
Oh, okay.
And there had not been insurance on the vehicle for 2 years.
I see.
So either the vehicle was misappropriated or
what a lawyerly word in
trying.
that context, right?
I was a public defender a long time ago, so it's still in there. It
There
never
you go.
leaves.
Okay. So I saw a number of motions in limine that generally what my practice is to have, if this case is really going to go to trial, probably the Friday before, we will have like an hour-long Zoom hearing, and let's wade through those motions in limine so everybody's clear on what can and cannot be said. Most of the ones I'm seeing in the motion in limine fall into the category of please follow the law, which is, I understand as a lawyer, I understand why we all feel the need to put those things in there. But there are most of these are very straightforward things that are not allowable, and I would not anticipate anybody trying to do them. But we will, to the extent necessary, make sure that we enter an order. What I will ask the parties to do is to submit to me a proposed order on the motions in limine in Word format. And the reason that we do that is because the Court of Appeals has expressed a very clear preference for written motions in limine or orders on motions in limine, so the parties are all clear on what they can and cannot do. And usually it will be something very straightforward, but I prefer before the trial to have an actual order in limine that you guys can have at your desk that says yes or no, you can or cannot do this. Beyond that, do you anticipate you're going to offer, I was looking at your, do you anticipate there's going to be any offering of deposition testimony other than for purposes of cross-examination or impeachment?
The only deposition that has been taken is of the plaintiff.
Mhm.
And so unless he was unavailable for trial, I don't anticipate that. I certainly wouldn't put it in, but
Okay.
Miss Larkart might, unless there's any doctor's depositions they intend to take prior to trial.
Okay.
We don't intend to use any of the deposition testimony from Mr. Murray. depending on if we are unable to get this settled, then there may be some expert depositions that we take. But as of now, no, there's no
Okay.
deposition.
Okay. And then to the point I made earlier about documents, in the proposed CPTO that y'all submitted, I appreciate you did list documents that you anticipated, but to be clear, what I would expect, for example, where item 2 says photographs of the involved vehicle. By the time we get to trial, I would expect that to be exhibit 1A through whatever, or exhibit 1 through 20, whatever, however you want to label them. But I would expect them to be pre-labeled and separately labeled for what they are. That would also include medical records. I, expect that providers will be identified separately, so that we can have a meaningful conversation about whether or not all of those exhibits are going to be admitted by stipulation, if there are specific internal discussions we need to have about medical narratives, things like that. The best way to do that and to keep our record clean of what's coming in, what's not coming in, and to have conversations about internal parts of those exhibits is to have them separately listed. And so that is my main request prior to trial, is those two things: the motion, an order on the motions in limine that are actually pending, so that when we have the motion in limine hearing, I can just rule on them, make a note, and then enter a written order on the docket.
Okay.
Oh, and one last thing. I do my jury charges on I put them into a PowerPoint, and that way they're on the big board and the jury can read them while I'm giving them. And then I do provide the jury with a copy of the jury instructions. The reason I say all that is that, especially in cases where this is well-established law and we're dealing mostly with pattern charges, you don't need to send me a whole big long list of the actual text of every charge you want me to give. If your charge is a pattern charge, just send me a list of the pattern charges that you want me to give. And if it is a non-pattern charge, and I think my standing order says this, and I think my pretrial order says this, if it is a non-pattern charge, give me the text, but you also need to give me at least 3 citations that demonstrate that it is good law, and bonus points if you can demonstrate to me that it's been given as a charge before. I'm always interested to find areas of established law where there is not a pattern charge, because I'm also on the pattern jury instruction committee for the state bar, for this Council of Superior Court Judges. And so y'all can always help educate me and sometimes fix holes in our pattern charges if there's not one there. But all of that also should be a caution to you that I'm not a big fan of gilding the lily. If there is a pattern charge on a topic, please don't give me 3 other things that the Supreme Court has said about that topic. If it was, if the pattern charge addresses it, then that's what we're going to go with. Other than that, my review of your pretrial order, Ms. Devon and Ms. Larkhart, appeared to be in order. And appropriate to go ahead and enter, unless you guys had any additional questions or wished to raise anything else. So what would happen is, at the end of today's hearing, I would go ahead and enter the CPTO that you guys have submitted. I'll sign it and enter it. And the only caveats to that, subject to, is to the extent that motions in limine are raised in here, I'm not ruling on those motions in limine. And that there would be a subsequent order on motions in limine, and I would expect to see a new exhibit list at some point. But other than that, your proposed order is fine, unless you guys have anything else you want to address with me.
I only had one
Sure.
request. I saw on the either the standing order or the pretrial notice that the motions in limine were due before this morning, and I did not catch that. Can I have until Monday to submit? I don't follow the law ones. I don't know that I will have any, but just to be extra cautious to make sure I'm not overlooking anything.
Okay. I think that's fair. I try to be a little So the reason I require them to be due today is because I think it forces the lawyers to actually give some thought to their case before. That's why I require the CPTO so far ahead of the trial, because it makes you actually sit down and think about what your case is, and then maybe y'all decide you want to resolve it. But also I do try to be a little forgiving, because sometimes you're doing this at a point where you're still not sure if you're actually really going to trial. So yeah, I don't have any concern with that, unless Ms. Larkart, you have some specific objection or concern about it.
No, Your Honor, I don't.
Okay. Thank you. So yeah, that will be fine, Ms. Devon, if you want to submit some motions in limine to follow along with the ones for Ms. Larkart. But to that end, the proposed order on motions in limine, I do require that it be a consolidated order. And that's because I am very much of the, if it's good for the goose, it's good for the gander category. So that means that if Ms. Devon says that nobody can talk about nobody can make golden rule arguments, well, that means nobody can make golden rule arguments, not just one side, obviously. And so generally speaking, it will almost always be, unless there's some unique issue, if you're telling me that the plaintiff shouldn't be able to do it, then that means nobody gets to do it. So my orders in limine, when I enter them, will say the parties are prohibited from X, just to be clear. Okay. And so the reason I said that, Mr. Bond, is when y'all submit that proposed order, you'll make sure that it has all of the proposed motions in limine, so that I can rule on all of them in one document. Okay.
Sounds great. Thank you so much.
Excellent. Good luck at mediation. Otherwise we will give you, these are the only two cases that it looks like are going. So you can be assured that you will probably be going the week of June the 24th, unless you resolve your case. And I don't have in front of me right now which one is older. But let's see, it looks like the Loving Good case is older, so you might be behind it. But I reserve the right to call them in any order, so just never know what I might do. In any event, I think that takes care of everything that I needed from you on that Murray case. Is there anything else y'all need from me, Ms. Larkart and Ms. Devon?
I have one request.
Sure.
Does the court have placards with the numbers for the jurors to hold up? I have some.
Oh no, I have tons. I think I have like 5 sets, and they go all the way through 90.
Yeah, because I'm a little visually impaired, and so like it's hard for me to see like 32, 33, and
first of all, mine are either hot pink or neon yellow. And second of all, I call out the numbers for you so that y'all can just write them down and don't have to worry about it. And I also don't always work, but I also try to call them in numerical order. So it's easier to keep track.
Great. Thank you so much. I really
Thank
appreciate it.
Have a good day. You both may be excused unless you need anything else from me. I'll get your PTO on file.
Thank you so much. Have a great weekend, everybody.
Thank you. Mr. Freehoff,
Yes,
Citibank.
Judge.
Citibank.
All right, I'll circle back to some of the ones you asked. I think we already dealt with Mr. Brennan because the plaintiff did not appear, so we're dismissing that.
Yep.
Moving on to, we're going to give Mr. Yacklin a chance to appear in the week of 6/24. On the Citibank versus Eric Jordan, Ms. Acullo, or no one in her firm, including her, opened the notice. For Discover Bank, we talked that Ms. Rose James did receive notice via mail. And on Citibank versus Jason Aguilar, again, same attorney, Kezia Acullo, no one, including her and her firm, opened the notice.
Okay, those two matters are going to be dismissed. Citibank versus Eric Jordan and Citibank versus Aguilar are both dismissed without prejudice. Okay. Loving Good. Thank you all. You win the prize for being the most patient. Thank you for your time. I appreciate it. But the reason I wanted to spend some time with y'all is I am aware that there are dueling summary judgment motions. A couple things you should know. One is my standing order says you don't get to file a reply unless you ask permission to file a reply. It doesn't have to be a motion, but you do have to email us, and nobody did. So I've read all the briefing except the reply brief. So
Your Honor,
just to let you know, yes.
if I may, I believe that myself and Ms. Scott had requested permission with Mr. Freehoff to file replies.
Okay, Mr. Freehoff, he did not recall me asking or me granting permission, but that doesn't mean, given the volume, that we didn't overlook it. So I simply say that to say I haven't read it yet. But even when I said that, my point was simply that oftentimes when I'm having these hearings, I'll be like, if you want me to read it, I'll read it, right? But, you know, I just haven't read it yet, was mainly what I was trying to communicate to you. And the reason why. But I will say this, as I understand it, you guys have a CPTO, but the two main issues are that there are cross motions pending for summary judgment. Number one. Number two, there is a disputed issue related to whether or not a jury trial is appropriate in this case. And there is also, I think, a motion for continuance, but I believe that motion for continuance might be a strong word, but is mostly associated with the parties wanting the court to rule on the summary judgment motion. If there's more to it than that, let me know. But what I wanted to do is to preview to you that I have spent a good deal of time with both of your motions. And one of the reasons I would like to talk a little bit about what to do with this jury selection or the jury request is because I am based on my review so far, as much as the parties both continue to suggest that these are non-disputed facts, that the import of those facts are really what is at issue, I keep coming back to a few facts about what people knew and what was reasonable. And when I start looking at issues about reasonableness and what people knew and when they knew, I'm not as sure as y'all seem to be that those issues are in fact undisputed. Number one. Number two, I do think we need to talk a little bit about and let me back up and say, I'm not expecting the parties to be present here to argue their summary judgment motions. No one requested an oral argument on the motions, and I don't intend to accept oral argument on the motions. I intend to provide you with a ruling in the near term, which is why I have not so far excused the parties from the upcoming June 24th trial calendar. I do, however, want to ask a couple of questions. The U.S. Bank National Association has taken the strong position that Ms. Lovingood's documents, that some of the facts that are not in dispute, it's because no evidence, no authenticated, reliable evidence has been presented on certain issues. And I wanted to ask generally a question, is that a topic, if this case proceeds to trial, is that a topic that is going to continue to arise?
Your Honor, I would say that any kind of issues that we had with the authentication, I would address those in a motion in limine prior to the trial. So they wouldn't we would get all of that resolved prior to that.
Okay. Okay. Thank you. I appreciate that. So next issue, my understanding, and by the way, Mr. Freehoff just went and searched his email and did locate the request. And so you guys are all good. And I will review the replies before I issue a final ruling.
Yes, I apologize for that.
Don't worry about it. It's not like we all don't have 8,000 emails at any given time. So, okay. So next issue is the issue of a jury trial. So I believe procedurally where we are is that this matter, U.S. Bank filed this matter seeking equitable relief only. They did not request a jury trial, and the case has proceeded for quite some time without a jury trial request until within the last month, I think, maybe a little bit longer. Can't swear to that because I don't have the docket open in front of me. The defendants requested a jury trial. And generally speaking, I think Georgia law is clear that that as an abstract proposition, that you can never fully waive a jury trial, and that if a jury trial is appropriate and somebody finally asks for one, the better course for the court is to grant a jury trial. The caveat to that is that the only relief sought in this case is equitable in nature, and that it is within the court's discretion to allow a jury issue, a jury to determine factual issues that would then be dispositive in terms of the court would then be bound by those facts in determining their effect on the equitable and legal issues that are in dispute. Is everybody generally in agreement with that? That is the legal landscape that we're dealing with, Ms. Scott?
Yes, Your Honor, for the most part. I would just add that we've done a little bit of additional research on this. The plaintiff does have a claim for declaratory relief, and the statute OCGA 946 does provide for a jury trial when the declaratory relief hinges on issues of material fact. So if the court determines that it cannot resolve this matter on summary judgment, which I think both sides agree this is appropriate for summary judgment, but if there are issues of material fact that still need to be determined, I think under the declaratory judgment statute, that would be appropriately given to a jury for a special verdict on the factual issues. The other issue that I would just mention is the defense of latches has been held to be an appropriate issue to for the jury to determine. And I can give you cites on that if you would.
And that, you correctly anticipated my next question, which is that was one of the points I made when I said, when you're talking about issues of reasonableness, that is one of the issues that stood out to me about, even if the parties agree on the time frame, is it appropriate for me as a matter of law to decide that that either does or does not rise to the level of being barred by the doctrine of latches? That's just previewing one of the issues that I'm sort of working through as I'm considering these briefs. Okay, what are your thoughts on that, Ms. Whitehead?
Your Honor, I would say that the declaratory judgment relief is it's an add-on count for the claims of reformation and equitable subrogation. It's not simply a declaration that we hold this in the property. The declaratory judgment is based on whether or not these equitable claims are granted. Concerning the issue of latches, I would be happy to read that case law if I could be provided the cites as well. But since I haven't read that, I know that factual determinations for latches can be brought to a jury, but I'd like to do some research on how that applies as a defense to our equitable claims when it goes to a jury. I just haven't done the research on that.
Okay. Okay. And so working through the actual CPTO that has been submitted, the estimated time that was requested for trial was 2 to 3 days. Does that include the possibility of jury selection? I understand that part of the argument against jury selection is that it would, expand the resources that are involved and the time that's necessary to select. But does that 2 to 3 days include selecting a jury?
I think the 3 days would include selection of a jury. Ms. Whitehead and I have discussed, we think presentation of evidence could probably be done within 2 days. So we were thinking 2 to 3 days, depending on whether it's a bench trial or a jury trial.
Okay. And any unique issues that might require us to need more than 36 jurors to get a jury?
I don't believe so, Your Honor.
I don't believe so.
Okay, the only outstanding motions, other than the motions for summary judgment, are the motion for a jury trial or request for jury trial and the objection that's been filed. And then the motions in limine, which you guys have heard my whole big spiel about the motions in limine. What would happen is just to make it a little more clear for you guys, if that's what we need to do, is June the 24th is a Monday. What is likely to happen is that on June the 21st, I would probably call the parties in on June the 20th or 21st for an hour-ish by Zoom to work through our motions in limine, to the extent that we can dispense with any of them that, again, fall into that category of please tell them to do what the law says. That would be much appreciated. But whatever you do, please submit to me a proposed order on all the motions in limine so I can have one order and enter it in the record. I'm aware that Miss Lovingood, based on the briefing, is having some issues associated with dementia. How significant is that? And is that a concern that I am in terms of her ability to participate, or that she is or is not going to participate actively in this trial? Ms. Scott?
That is an excellent question, Your Honor, and something that we are really trying to grapple with. I think there's some borderline there. I mean, she certainly knows what she wants in terms of being able to keep her home. And she's able to say that she doesn't remember any of, the loan transactions. She's able to, testify to what she can remember and what she can't, which is not much that she can remember. I am concerned about the emotional toll that this is going to take on her, because I think for her following along and not understanding what's going on and not being able to remember in order to aid in her defense is very distressing for her. Every time she comes into my office, she becomes very emotional about it. So I do want to be mindful of those concerns, but I also don't know whether it may be necessary for her to take the stand for a very limited purpose to just establish that she really can't remember anything related to this transaction and kind of, the effect that this would have on her.
Okay. What are your thoughts, Ms. Whitehead?
Well, Ms. Scott and I had discussed this, and I had done some research on the law about obtaining judgments against a person with dementia. And what I found under the rules is that persons with dementia and memory issues, judgments can be had against them as long as there's something in the record saying that their interests were properly represented. Yes, adequately represented. So Rachel and Ms. Scott and I had gone back and forth on whether to do a motion for a GAL or adequate representation. Then we decided we would just bring that. We thought it would get brought up today. Obviously, Ms. Scott and Atlanta Legal Aid are here. In no way am I going to say that they do not adequately represent their clients. I know that they do, just because of the time we've spent on this trial and the level of detail we've got into it. But we would request something being put in the record that her interests are adequately represented. And if Your Honor feels differently, a guardian ad litem would need to be appointed. We have stipulated into our stipulated facts that Ms. Lovingood has dementia, and I believe that she doesn't remember the events of this loan transaction. So I think with that stipulation, we wouldn't need her to testify as to that and put her on the stand, because I do think there would be issues of competency.
Okay, so that might be something that the parties can stipulate to, in terms of that she doesn't have an active memory or recollection of these facts, something like that. Okay.
We may need to expand that to include, she doesn't remember the facts surrounding her bankruptcy case, because there are other, aspects of this timeline, that she doesn't remember signing this forbearance agreement that the plaintiff is relying on. or, what the circumstances or her understanding or intent was at that time. And we may need some additional stipulations that she can't remember any of these things in this chronology, to ensure that, there aren't any questions about that for the jury or for yourself as a trier of fact if you hold it as a bench trial.
Okay. Okay. The only other thing I will add, other than some of the stuff that y'all have already heard me say about, for example, the list of exhibits, by the time we get to trial, I would expect it to be Exhibit 1 is the 1965 warranty deed. Exhibit 2 is the 1974 warranty deed, or whatever, plaintiff's Exhibit 1 versus defense Exhibit 1. Obviously, many of these documents are public record documents. And so it ought to be that the vast majority of these documents we're all in agreement, and they can just come in and, we can move on and limit our discussions to actual documents that we need to have some, foundation laid, or there might be relevance issues or, whatever. But the vast majority of these documents, it doesn't seem like there's a whole lot of dispute. Certainly the ones that are a matter of public record in the Superior Court of Fulton County. And then, some of the loan agreements and forbearance agreements, obviously there may be issues associated with substantively what those things cover, but it doesn't seem like in reading the summary judgment motions, there's a dispute that those documents are what they are, et cetera, whether they were signed and then the circumstances of their signing might be a different issue.
Your Honor, we may have a motion in limine on some of the documents from the loan file. We do have some concerns about the trustworthiness of some of those documents from the loan file that bear different loan numbers, and there's really no explanation as to how that occurred or a way to verify that these were really the final documents associated with the security deed. So we anticipate we may be
and that's fine, but that's the time to have that conversation, is that right before the trial, when you guys have actually pulled together the documents and you've looked at what they're going to use and said, I don't care about these 50 documents, but these 3 documents, let's have a conversation. I would imagine that Ms. Whitehead probably is going to say the same thing about some of the documents based on what I've read in the summary judgment motions about some of the documents that Ms. Lovingood is relying on, which are just, documents she had in her house that, about the loan or whatever. So we will, we're gonna have to sort through all those things before we get to trial. And we will do that on, like I said, probably the Friday before. Last thing I will note, if this case goes to trial, the list of interrogatory verdicts is very unwieldy. And we're going to have to work together to try and limit that and write it in plain language. I'm also part of our job on the Pattern Jury Instruction Committee is to rewrite our charges in plain language and not complicated English, Latin law language, which especially when we're dealing with property, it can happen. And so we need to make sure that our whatever, if we are going to present the jury with interrogatories to resolve factual disputes, that they are 1, in plain language, and 2, non-argumentative. And I noted that the parties indicated that the possibility of settlement is poor. Tell me a little about, 1, have the parties tried to mediate? If you have, I don't want to know the ins and outs, but I would like to know, to the extent you're comfortable sharing, where the breakdown is. And I suspect the issue is there's not a halfway remedy here. Oftentimes everybody can find a halfway remedy, but that really the issue here is there's not a halfway remedy. But I would like to hear more about why the options of a resolution are so poor. Let me start with Ms. Whitehead, since you are the plaintiff.
Yes, we have not gone to mediation on this. Pretty much during the entire litigation, as you said, there's not a halfway here. Either the security deed will encumber the property or it won't. I will say in the most recent weeks, I've been having discussions with my client about settlement, and Ms. Scott and I are discussing, but obviously nothing has come yet. We would like to see what the motion for summary judgment order says, understandably. So we are having discussions, but whether or not it could resolve, I'm just not sure at this point.
So one thing I should warn you is that just so when you say we'd like to see what the summary judgment order says, one thing you should know is that because of the sheer volume on this end, in order to be efficient and make sure that my orders get entered timely, what I typically do, and you guys will probably be getting something Monday or Tuesday, maybe this weekend, but it may be that Mr. Freehoff gets it this weekend and y'all get it on Monday or Tuesday. But what I will frequently do is I will draft an email that distills down what I think is the primary issue and say, I'm ruling in favor of X, and this is the basic reason why. And then I will ask whichever party I'm ruling in favor of to submit to me a proposed order that I will then rewrite to reflect what I have said. And the only caution I will add is that should I do that, it is not an opportunity to re-argue your case. And please don't, you know, if I send you an email that says I'm finding this because of A, B, and C, don't send me a proposed order that says I'm finding this because of all the other things you said in your motion. I say that only because, particularly in this case, because the factual issues are so detailed from each side in terms of what happened when and how it relates to the recording of the deeds, the taking out of the loans, the relative significance or not of the bankruptcy issue, the facts of this case and what is and is not disputed, undisputed, and how it relates to the issues is going to be so important that this is definitely an order that I would ask for proposed orders from both sides, if nothing else, simply because it's any order that goes up is going to need to be detailed for the Court of Appeals to be able to go through it, should it go that far. So I warn you that likely my intention is to advise the parties after I read the reply, to advise the parties what my ruling is going to be, and to ask the parties, one side or the other, to submit a proposed order that I will then get on file for you as quickly as possible. If it leads to an appeal, you know, that's fine. If it does not, then it will be one of the reasons I want to get it to you as quickly as possible is so that the parties are clear about the need and extent to which everybody needs to be preparing for trial. I am going to look, Ms. Scott, and let Ms. Whitehead look as well. And if you would like to submit an email, and very brief, on the, I'm familiar with the case law on declaratory judgment, right? That there is a universe in which that allows for a jury trial, separately from something like a true equitable type remedy. Although oftentimes a reformation is usually in the context of, say, it comes along with some sort of breach of contract. So this is a little bit unique that it does not. But I would also like, you mentioned some case law about latches, entitling a party, or maybe not entitling, that's not the right word, but implicating maybe a more better reason to allow a jury to sort out some issues. If you could send that over to me, if you've looked at that recently. Obviously, if I grant summary judgment in either direction entirely, none of that's going to matter. But I do think that we need to get an answer to that so that the parties can figure out how to prepare, jury versus no jury. And so if you can send over that in short order, Ms. Scott, and then Ms. Whitehead, maybe Monday, And then Ms. Whitehead would have an opportunity to respond by say, I mean, today's Friday, so I'll give you until Monday. I hate to make you work on a weekend, but the only way I can keep it to 2 days, and then Ms. Whitehead would get until maybe Wednesday, or to respond. And again, I'm not asking for you to write me a big long brief. I just need a sort of basic, point me to the case law that you would rely on to make your argument, and I will go read that case law and advise the parties of how I'm going to proceed and whether or not we're going to have a jury for the entire case, for some limited interrogatory fact-finding exercise, or if I am going to accept the defendant's request to, excuse me, the plaintiff's request to proceed in this case without a jury, which is what I think everybody anticipated until the recent filing of the request for a jury. Anything else y'all need from me other than to sign the CPTO and get it on file and then get you a ruling on your summary judgment motions? Ms. Scott?
I have a couple of matters, Your Honor. One question, if this is going to trial, I have one question about your position on allowing third-party witnesses to testify by Zoom. I'm
a huge fan of Zoom. There will be a Zoom. Nobody has a constitutional right to confront their accusers as I do in criminal. The only thing I do request is that I think that the way the rule is written now, that the parties must consent. And so I would expect that if anybody objects, that there's a reason for the objection and not just to let's all be difficult and make everybody's life difficult. But if somebody has an objection, they need to bring it to my attention. But for the most part, I think it makes everybody's life easier to let people testify by Zoom. Like I said, there's a giant screen right next to the jury, and it's right next to the witness box. So the person testifying is there, and I will charge the jury that that person is testifying live, just as if they were sitting in the jury box, and that you should treat them just as if they had walked in here and sat on the witness stand. So that's fine with me, and we have the infrastructure to do it.
Okay, thank you. The other item is something of a scheduling thing that I'm trying to navigate. One of our witnesses, the bankruptcy attorney who provided the affidavit about Mrs. Lovingood's bankruptcy and the availability of lien stripping during the time of her bankruptcy case.
I'm sorry, the availability of
being able to strip off a second mortgage during the time of her Chapter 7 case.
So if y'all are trying this case to me, y'all should definitely know that I know the only thing I know about bankruptcy is the automatic stay. That's what Superior Court judges know about bankruptcy. So if you're going to throw bankruptcy lingo around, y'all should definitely educate me as we go. But anyway, go ahead, Scott.
So that attorney is not available until that Thursday, the 27th.
The 27th?
The 27th.
Okay.
I've explored with him. He's on leave. He said he's scheduled from 6 a.m. until 6 p.m. other than a short break for lunch. I was trying to explore whether he might be able to appear by Zoom during the time that he's on leave. And it sounds like he's really not going to be available until that Thursday.
Okay.
I wanted to just explore options. I know there's another case on this trial week that's set for 3 to 4 days, I believe. So I just didn't know if we were to start on Monday, we may go into Wednesday, but if it would be possible to recess or come back Thursday for his testimony before closing.
Well, my calendar is open that week, other than the fact that I'm presiding, which I'm sure my staff is like, please stop doing stuff while you're presiding. But I mean, the simplest option, depending on what Ms. Whitehead says, what her position is, I mean, you guys have announced 2 to 3 days. I can pick a jury on Monday, the 24th, or I can pick a jury on Wednesday, the 26th. And so if realistically we can pick our jury in the morning, get started in the afternoon, then this really is a 3-day trial. And there's no reason we couldn't expect to, start the trial on Wednesday, the 26th, and then proceed through the 28th. And then, I even am open. I would hate to bring juries back the week of July the 4th, but we could roll over into that Monday, July the 1st if we needed to.
Would it be possible if we have a jury trial, would it be possible to start on that Tuesday?
I probably can. I just have to switch with somebody because I get 2 jury days a week. And they're on alternating Monday, Wednesday, Tuesday, Thursdays. And so for that week, it happens to be Monday, Wednesday. I can probably switch with somebody and make it the 25th, which would be a Tuesday.
Just so that you're aware, sort of the reason I'm asking for that. I am actually leaving Atlanta Legal Aid. My last day was supposed to be June 14th, but I'm staying on to complete this trial. We are going to try.
That's dedication, Miss Scott.
And I will not be able to continue on into the following week.
Because that would be the end of the pay period and it would complicate lots of things, right?
And I unfortunately am not going to be allowed to continue working on this case in my new position. So, and Ms. Brown has her son's wedding starting that week of
that's exciting.
July 1st week, or that weekend beforehand. So we're trying to complete this if at all possible.
Those are all really good reasons to try and start it on Tuesday. Ms. Whitehead, what are your thoughts?
I have no objection to it. I will be having an out-of-state witness fly in, so if we can have a definitive date that we would start and when we would have their testimony, I would prefer that just because they are coming from out of state.
Yeah, that's easy enough. I mean, it's just a matter of making a few, and it's far enough out from now that it's just a matter of sending a few texts to confirm that I can steal another judge's jurors for the week for the day of the 25th. So I'm going to make a note that if we are going to go jury trial, that it will, well, actually, here's what we're going to do. It's just going to start on the 25th. I just need to confirm that I can borrow jurors if we need jurors. So what the parties can do, and that would also make it easier because then we could plan to have our pre-trial meeting on motions in limine on Monday, the 24th. So let me confirm, and we will send you an email no later than Monday that we have confirmed we can switch jurors switch with another judge, and that this trial will start on the 25th, and we will have the ability to select a jury on that day should we need to. That will also mean that you will receive a notice of continued pretrial hearing, basically, where we will go through any exhibit issues and also deal with motions in limine. Anything else, Ms. Scott?
That's it. Thank you so much, Your Honor.
No problem. Ms. Whitehead, any concerns, questions?
Ms. Scott and I did have one disagreement, and this is within the special verdict form that you were speaking about. We were torn between clear and convincing evidence and preponderance of the evidence as a burden of proof as related to the equitable subrogation claims. We've both done research, and I know Ms. Scott has thoughts on this, on why it should be clear and convincing. I don't believe we found any case that clearly states that, but I just wanted to bring that issue before Your Honor so we could in some way make a determination of how this will proceed.
Okay. So let me say that generally speaking, my approach, and I think my understanding of the law is that the default standard of burden of proof, standard of proof, is always preponderance of the evidence in a civil case, absent specific direction that a different standard should apply, particularly where you're talking about a higher standard, such as clear and convincing. And so for me to apply a clear and convincing standard, or to instruct a jury that that's the standard they would need to apply at trial, I would definitely need to see some case law that supported the position that something other than a preponderance of the evidence was necessary to satisfy the equitable. It sounds like it's only related to the equitable subrogation issue. And so what I would invite you to do is, if you want to educate me on that issue, y'all can, I mean, you don't need to necessarily send me anything on that topic because I'm not going to rule on it until we get to that day before, and we're finalizing everything about what a verdict form would look like. But y'all should be prepared to educate me about that topic in terms of the research that you've done. Presuming based on Ms. Whitehead's outline and preview of the issue, that it is going to be the plaintiff's position that it is preponderance of the evidence for everything because it's a civil case and there's no specific directive in case law or statute that says it would be a higher standard like it would be for, certain types of damages, et cetera, certain types of claims. I understand that Ms. Scott, your position is going to be that as to the equitable, claim on the equitable, my brain has just.
Equitable subrogation, Your Honor.
Thank you. Subrogation was the word that would not come to me. As to the equitable subrogation claim, that perhaps there's some case law you want to direct the court to, that there might be a higher standard for that one. And I will take that up when we have our pretrial hearing on the 24th. Anything else?
I don't have anything else further, Your Honor.
Can't think of anything else. Thank you.
Well, then what I'm going to do is go ahead and get your pretrial order on file. And then I will see you. I will provide you with a ruling no later than Tuesday of next week. And if it is a grant of summary judgment, then I guess you can all, it'll just be a matter of getting the order on file, and then y'all can all appeal whichever way everybody's going to. If I deny summary judgment, then y'all will then know that we need to move forward with issues associated with resolving these discovery issues or the evidentiary issues, motions in limine, and the use of a jury.
May I ask, I'm sorry, just on the summary judgment ruling, if Your Honor does deny the motions, there are a couple of legal issues within the motions that have been filed, and I'm just not sure if you have an opportunity to rule on those to give us some guidance, or if we will revisit those before trial. In particular, I'm thinking of the issue of standing and the issue of subrogation to the 1998 security deed that is now expired. Seem to be legal issues rather than issues for a jury. So just wanted to ask for guidance on those if we are going to trial.
Well, that's one of the reasons that I need to finish getting through the summary judgment motions, because even though I'm not going to write a full order, when I send you an email that says this is my ruling, I do my review so far tells me that whatever I do is going to need to be somewhat detailed in the sense of I've considered this issue and this is the ruling. I've considered this issue and this is the ruling. Because this is not a case where you're going to get an email that says, yep, there's too many disputed fact issues. Which I truthfully sometimes do say in car wreck cases where some people sometimes actually file summary judgment motions. But so I will try to give you some detail to the extent that those issues are not dispositive of the outcome of the summary judgment motion, then those are issues we'll need to take up in terms of if those are matters for the court to resolve prior to trial, or if those are matters that will need to be demonstrated to the court as part of the parties' respective proof of their cases.
Thank you, Your Honor.
Okay. Everybody have a good weekend. Hopefully the weather will hold out. We can have a nice weekend for a change without some rain. And I will get your PTO on file, and I will be in touch with a ruling on the summary judgment motion in short order, or summary judgment motions, I should say, in short order. Thank you all. Have a good weekend.
Thank you.
Thank you.
Bye.